Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1189, BIU LLC petitioner versus Federal Communications Commission and United States of America. Mr. Greenberg for the petitioner, Mr. Hellman for the respondents.
Good morning, counsel. Mr. Greenberg, please proceed when you're ready.
Good morning, Your Honors. Alan Greenberg of Greenberg Gross for the petitioner. Raise this a little bit. May it please the court. The two principal cases cited by both sides both involved dismissals without prejudice, Listeners Guild and environmental. In this case, it is not clear why the FCC dismissed the matter, the underlying petition, with prejudice. It involved highly suspicious circumstances. The request for withdrawal by Spectrum 5 did not state that it was requesting that the dismissal be with prejudice. The underlying petition that Spectrum 5 had before the FCC implicated ongoing wrongdoing by Intelsat and alleged credibly with supporting information and citations to evidence, complicity by the FCC itself in allowing two rogue satellites to violate the license that they had from the FCC, to violate the standards of the international, the ITU, the International Telecommunications, and it was a matter involving billions of dollars of revenue as alleged in the underlying petition.
It seems like all of your arguments are going to the merits of the case. What about the procedure with respect to the two untimely orders?
Well,
Petitions?
so thank you, Your Honor. In the face of those merits, the fact that the dismissal was inexplicably or entered with prejudice on a withdrawal that was inexplicable under those circumstances potentially subverts the integrity of the commission itself. And so under Listeners Guild and environmental, the FCC's argument that it should not hear a contractual matter is not supported by those cases. Those cases specifically allowed the interested party to come back to the FCC if, as and when they were successful in a state court forum, and that's not true here.
In the FCC's brief on page 17, they first say there's no reason why it, meaning your client, cannot have the underlying contractual dispute adjudicated in a form that routinely considers contract claims such as state court, and then go on to say, and should BIU prevail in establishing its rights, it can return to the commission armed with a court judgment and seek reinstatement of the Spectrum 5 petition or other appropriate relief. Let's suppose that that's all true. If that's all true, then your with prejudice, without prejudice argument and starting point doesn't matter. Am I right about that?
Well, it would not matter if it was without prejudice. In other words,
but let's suppose that the way they're viewing with prejudice, because it's with prejudice entered by a commission body. So I guess the commission gets to determine what it means to be with prejudice vis-a-vis the commission. And if this is what the commission thinks with prejudice means, then the distinction between with prejudice and without prejudice, as I understand it, ceases to be consequential.
it seems like awfully cold comfort to the petitioner in that they say that the petitioner can seek to reopen. They don't commit that they won't just deny it out of hand as being untimely.
Okay, I take that point, but let's suppose that they don't dismiss that out of hand on the ground that, what are you talking about? Our prior one was with prejudice. They don't just mean, you get to file something and then immediately get rebuked. If it really means that if you go to state court and you get what the kind of determination you want, and then you can still go back to the commission and have it not be precluded by the fact that there's already been one go at it for the commission.
I
And
agree.
if that's true, then you'd be in good stead.
Yes, I agree with that because it would be in effect without prejudice, even though it's called with prejudice. But like I was saying, I don't know that that page 17 of their brief is binding on them at this point.
Sure, we can ask the commission whether it means what it says here. But I just wanted to make sure that I had understood the lay of the land from your perspective.
Thank you, Your Honor.
But when you go to state court, you are having allegations of fraud and, you know, failure to pay loan, and that would be a monetary damages remedy, correct?
Well, the BIU, the petitioner, is a secured lender, and its collateral includes the rights that are involved in the underlying petition. So if someone were to pay them in full, then it would just be a monetary matter. But that's the nature of being a secured creditor. They have collateral and they have an interest in state court. They could get the right to pursue
But I guess
the
I'm
collateral.
getting at what your claim is. Your claim seems to be a default on the loan. And so if you're going to claim a default on the loan, isn't that a monetary remedy that's being sought?
Well, it is if there's an ability to pay the loan from some source. Otherwise, that's the nature of being a secured creditor versus an unsecured creditor, is that this collateral exists, which includes the contract right to enforce 95 West slot. And so if successful in state court.
What is it that you understand that if the commission says this is a private contractual dispute that is going to be sent to state court, what is the claim and then what is the potential remedy? Like how are you made whole then?
In state court?
Yeah.
Well, what would happen is BIU would go to state court and seek to get a ruling that they can enforce their collateral because the FCC does not wish to entertain that. So if a state court said that a BIU could foreclose on the collateral and receive the contract rights that it's entitled to, then it would go back.
Does that end the claim?
No, it would not end the claim because they wouldn't be paid just from that. So and even if they got a money judgment, it wouldn't result in collection automatically. So that's the whole idea of collateral, is to then pursue the collateral to try to generate the money. So the secured creditor would come back to the FCC, hopefully in a manner that they can be heard on the substance, and continue the petition, the underlying petition in front of the FCC, and if successful, might actually be able to collect on the loan.
So the way you're perceiving of it, if you're successful, if this goes to a state court action and you're successful in the state court action, you'd still need to come back to the commission.
Correct, which is why we made the issue of the with prejudice, without prejudice. There are, just to address it for completion, there are some timeliness issues that came up in the briefing and in the underlying decisions. And the WSTE TV case does say from this court that the commission in a situation like this needs to consider the public interest in deciding, even if somebody did not file any petition for reconsideration, would need to decide, despite untimeliness, the merits of it. And so here, there's no indication of consideration of very important public interest. And so I'd like to reserve the balance of my time unless there's more questions. Thank you, Your Honor.
Time for rebuttal.
Yes.
Mr. Halban.
Good morning, Your Honors, and may it please the court. Igor Hellman on behalf of the Federal Communications Commission and the United States. This court should deny BIU's petition for review because the commission was reasonable in taking Spectrum 5's withdrawal at face value. That withdrawal came prior to BIU's involvement, and so that the with prejudice statement that occurs in the Enforcement Bureau's dismissal at Petitioner Appendix 105, that's before BIU got involved in any sort of allegations of I mean, the allegations were made in the initial petition, but this was before the allegations of fraud that BIU is now alleging.
And the consequence of that is what? So if I take that point that it was before the fraud stuff sort of came up.
Right.
Does it mean that even though the rejection was with prejudice, now that there's something new in the case, the fraud stuff that wasn't there before, that if the BIU goes to state court and ultimately vindicates its fraud claims in state court, that there's no with prejudice problem with it coming back before the commission before the Enforcement Bureau, because the Enforcement Bureau didn't have before it the fraud part of it to begin with?
That's correct, Your Honor.
Thinking about it? Okay.
Yeah, the statement that you read in our brief on page 17 is correct, that if BIU can establish its rights in state court, the fact that the dismissal was with prejudice is not going to prevent it from coming back to the commission.
And that means more than what counsel, sort of hypothesized and seeking to protect its client's interests. I can understand why that it doesn't mean just kind of a formal, oh, you can still come back before the commission, but then you're immediately going to be bounced. It means, no, if you actually get relief on your fraud claim, then on your fraud allegation, then there's no threshold bar to having your claim considered by the enforcement.
That's correct. If BIU can establish that there is fraud in the withdrawal of the petition, then the with prejudice language is not a bar to it coming back for that.
So the commission order didn't seem to suggest that they could come back after a state court judgment. That seems to be something the commission has in its brief.
Your Honor, I believe in the full commission decision, it talks about the role of state courts and to adjudicate this dispute in the context of BIU establishing its claim, its fraud allegations in state court. I don't know that the commission expressly said then BIU can come back, but it didn't say BIU can't come back. So
okay, so you're taking the absence of that language to mean that it's not precluded.
that's correct.
Okay.
And with respect to your question, Judge Childs, about what BIU can do in state court, BIU is seeking to establish that Spectrum 5 defaulted and that under the contract language, under the various agreements, BIU is the attorney in fact such that Mr. Wilson was without authority when he filed the motion to withdraw. BIU can establish those things in state court. If it's entitled to money damages or other things, that's sort of collateral or a different issue, but it can get a declaration that Spectrum 5 was in default as of a certain time, because that also matters as to when the default occurred. If it occurred after, then BIU doesn't have the rights that it claims. And that sort of contractual interpretation is a quintessential state court matter that the commission was certainly not acting arbitrarily and capriciously when it declined to engage in.
Right. So if BIU goes to state court, and to follow up on what Judge Charles was asking about, if BIU goes to state court and establishes that there was fraud in the withdrawal, and then whatever relief it gets in state court is irrelevant to the commission, because then BIU can come forward to the commission and say, look, the withdrawal actually was no good.
That's correct. Yeah,
okay.
That's exactly correct, Chief Judge Srinivasan. And BIU makes the argument, well, the state court can't adjudicate satellite license conditions, and that's correct, but the state court doesn't need to adjudicate that.
Right.
And what go ahead.
You're in essence saying, and this happens not infrequent number of cases, at least in the years that I've watched, if we write an opinion in your favor, among the things that would be recited is the assurance from the agency that if they prevail in state court, the agency agrees that they can come back to the commission. And that ends it. I mean, if a later court now gets the case and our prior opinion said we operated on the assurance from the agency that they could return, that's the end of it.
That's correct,
The
Judge
answer for
Edwards.
the other side.
Certainly, and if we take that position and we prevail on it, we are bound by that position. Certainly, we'd be judicially stopped if we then try to change our mind. And I do want to
Do
yes.
we then just forego these untimeliness arguments?
Well, they are independent grounds, Your Honor, and this court has certainly
They're independent? Are they independent?
the untimeliness and the determination, the merits what we're calling the merits determination. I guess the commission viewed them as two independent grounds. I suppose they could be intertwined in the sense that if BIU established fraud, then it would have a better argument to overcome the untimeliness. And it cited some cases in its brief where the commission waived its timeliness rules in the presence of unequivocal evidence of fraud. But
those cases seem to have undisputed evidence of fraud, but that's not what we have.
that's correct, Your Honor. That's exactly right.
So I'm trying to get a sense of, you seem to be agreeing earlier that the commission does take the position that if they go to state court and they get a favorable ruling, then they could come back, reopening the case or what have you. So then you would be foregoing the untimeliness arguments and allowing them to just come back to the commission in that regard.
If they can establish that the withdrawal was fraudulent, they could perhaps overcome their doubly untimely filing.
Okay, so you're leaving untimeliness on the table after they come back to the commission, like if the commission still wants to pursue that with respect to whether or not the appeal or of the petitions were timely filed. I'm just trying to get, are you admitting that they don't have to deal with that anymore? Is just let them get what their favorable ruling would be in state court and then they come back, or are you still leaving untimeliness on the table?
I think with a strong showing of fraud, they could overcome the untimeliness, but without a strong showing of fraud from state court, as their petition
Okay, and that would
comes.
be consistent with some of the prior rulings.
That's
cases.
correct.
Okay.
Yeah, but you're saying could overcome. I mean, if they got the determination of fraud that the commission is suggesting that they go try to get. If they don't get the determination of fraud, then obviously everything ends.
Right.
But if they get the determination of fraud, then is there still a bar to them getting their claim heard on the merits before the commission? A timeliness?
Timeliness.
I guess I was up under the assumption that there wouldn't be, but if there still is, then.
Well, so I guess I'll answer it this way, Chief Judge. At this point, they've made no attempt to overcome their double untimeliness. If they come back with a fraud judgment and say that these are extenuating circumstances, that could constitute a circumstance under which the commission could waive its timeliness rule. So I guess I don't want to necessarily speculate as to how they come back to the commission if they've prevailed, but that type of fraud could help them overcome the untimeliness.
The thing is that the view of timeliness is different if they come back. Your view of timeliness was as against this procedure and what was happening in it. That's all gone. They go to state court and get a judgment in their favor and they come back. You're not counting the 30 days from that prior period. That's all irrelevant now. And you have a court order, if you win, a court order that says you assured them that they could come back if they win. I'm just telling, based on my experience, you're making it harder than it really is. Based on my experience, if you have a court order like that and the commission sees it, they're not going to say we ignored. The court said we gave assurance and we're going to not let you come back because of prior untimeliness. That makes no sense.
No, I think that's right. If they have the order from the court concluding that there's evidence of, that helps them establish fraud, then their prior untimeliness is not going to
give it some consideration now.
That's correct.
And
Yes.
there's a new clock. I don't know when it starts or how we set that up, but it's certainly not the old clock.
That's correct. If there are no further questions from the court, we respectfully request that you deny BIU's petition.
Thank you, counsel. Greenberg, I think you had about a minute and a half left. We'll give you that minute.
Thank you, Your Honors. There's really only one point that I want to address in response. That, again, if BIU goes to state court, it will be under state law to enforce the loan documents. It will not necessarily be to establish that there was fraud in the withdrawal of an FCC petition, because that fraud of a withdrawal of an FCC petition would be a matter not of state law, but of FCC jurisdiction. In other words, what BIU envisions coming back with is a judgment that says that the loans were in default prior to the withdrawal, that BIU had the enforceable power of attorney. And we would then go to the FCC with evidence through discovery. We would be taking discovery to be able to present evidence to the FCC of the circumstances of the withdrawal, which are unexplained right now as to why it was withdrawn. And if those, so we wouldn't necessarily have a fraud judgment as labeled as such from the state court. It would be that we would come back to the FCC with a judgment that BIU has, the right to proceed. And then we would go to the FCC and show them the underlying facts that the withdrawal was improper and was not for a legitimate purpose.
Yeah, I think that's a fair point, but I think fraud was just shorthand for the notion that you would get the determination that BIU had the power of attorney.
Right.
And once that there's the power of attorney, then it triggers all the rest of the things that you're talking about.
Okay, that was the only additional point that I had. So unless there are more questions.
I think so.
Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 24-7064, Charles Turpin and Regina Jackson, appellants, versus District of Columbia, a municipal corporation, and Michael Chen, officer, in his individual capacity. Mr. Presley for the appellants, Mr. Phillips for the appellees.
Good morning, counsel. Mr. Presley, please proceed when you're ready.
Good morning. May it please the court. My name is John Presley. I'm here on behalf of the appellants, Mr. Charles Turpin and Regina Jackson. There are a lot of issues in this case. I wish to direct my attention at this point to a couple of key issues I think that are most important. I indicated the significance of what I call the colloquy, which took place between Mr. Turpin and Officer Lorraine. Now, that colloquy, which basically stated as follows, very succinct. Much indulgence here. No, I apologize. Okay, here we are. I'm sorry. The colloquy that I reference is as follows. This took place once the officers and so forth were in Mr. Turpin's apartment. And at some point during that time, Mr. Turpin asked the following question. How is it that you are able to be in my house? And you understand what I'm saying? Officer Lorraine responds by saying, we're here because we got a call for service. Mr. Turpin states, I didn't call you. Officer Lorraine remarks, okay, I understand that. That's a very short colloquy, but it carries a lot of weight.
But don't we need to put that into context, like the actual time that occurred? In other words, there was an initial invitation to come in. then the officers eventually follow Mr. Turpin toward the bedroom because Mr. Turpin is the one who says, there's my girlfriend, basically, she's right here, after the officer said, you know, who else is here? So don't we need to kind of put that in context as to when that exactly occurred? That's not at the initial onset of all of this.
That's a very important question, Your Honor, and I was going to get to that because the trial court indicated that it was taken out of sequence, and as a result, it wasn't relevant to what happened later. And I made
Would you agree that that did not occur right when the officers came to the home, right initially? Because then to me, that would be an
Correct.
important question to suggest, I'm not inviting you in. You need to tell me why you're here.
Correct. It did not occur at the beginning. It occurred later. As a matter of fact, they were in the bedroom at that time. My argument is that
So are you
once,
gonna agree that up until the bedroom scene, the officers were appropriately there with consent of Mr. Turpin, or at least no revocation of consent?
no, I do not consent that, I'm sorry. I do not agree that there was consent, but I think that what is clear is once the colloquy took place and once Mr. Turpin basically says, well, why are you here? Which basically says, well, what authority do you have? From that point, it's clear that even if arguendo, there was consent. At that point, it ends. And it's clear that
Wouldn't that be at the point where the officers had already seen the drugs?
no. And that's another important point. The drugs issue was not brought up until after the colloquy. Up to that point, there was nothing said about the drugs and so forth. And also what is very telling, obviously, about what Mr. Turpin says, he says, how is it that you are able to be in my house and you understand what I'm saying? If in fact, Officer Lorraine believed that there was consent, the response to that would have been, well, Mr. Turpin, we're here because you consented to our coming.
It's hard for me to believe that an officer on the scene, when we're taking into account the practicalities of officers that are going into a residence where they suspect that there could be some problematic interactions taking place, are supposed to have an oral argument about law. I mean, it's just, the way you're perceiving of it is what the officer should have said is, well, there's a doctrine called consent searches. And so if what you're asking is, am I lawfully here because I had a warrant to come into your residence? The answer is no, but I didn't need a warrant because I got your consent at the door. I mean, that's just not a realistic way of the way we would expect officers to interact with people in whose homes they've been invited. Is it? I mean, we don't even know what Mr. Turpin meant when he said, how is it that you came to be here? It's possible that that's what he's asking about, the legal authority. It might well be, but I don't know that in that situation, what we say for qualified immunity purposes is that a reasonable officer, in order to avoid being determined to have engaged in unconstitutional entry into the house and subsequent search of the house, is supposed to have said in that situation, well, let me walk you through the Supreme Court case law on what a consensual search is. That just doesn't seem like what.
Well, I agree with you that I wouldn't expect him to give a legal dissertation on consent. However, if in fact he believes that he did have consent, he could have merely said, well, Mr. Turpin.
What was the question was, how is it that you came to be here? Is that what it was? I mean, we're analyzing this language as if it's a statute, but still, we can do that. But how is that you're able to be in my house? I mean, I think it could have the answer had to do with why they were at the house as opposed to in the house. I mean, I don't know that because I think if the answer was we came to be here because we got some complaints about a disturbance. And that's factually accurate, I assume. And at that point, if the difference is why they're at the house as opposed to in the house, we're splitting things pretty finely as to what an officer is supposed to do in the course of a dynamic interaction within a residence where they've been invited to come in.
Well, Your Honor, the whole concept of consent is supposed to be voluntary and so forth, and knowing to some extent. I mean, you know, if that's their argument, that, well, it was consensual and so forth, then he should be able to just state that and so forth in lay language. It doesn't have to be a legal thing.
So what if he just, I mean, is your argument that when Mr. Turpin asked that question, that was a revocation? Let's just assume that there was consent to come in, because I think this argument assumes that. I know you don't want to give that away, but I think this part of your argument necessarily assumes that. And if we assume that, then is your argument that even if there was consent for the entry, that consent was revoked when he asked the question, how is it that you came to be in my house?
Right.
You think
Because
that's a revocation of a consent, just to ask the question, how is it that you came to be in my house?
yes, because they're basically saying that, well, you know, you said come in and you consented to everything and so forth. And if in fact,
So what if the answer would have been, we're here because you consented to our coming in?
yes, why not?
I'm sorry?
Yes, Your Honor. Why couldn't he say that? And
Right,
once
no, but
again,
I'm saying if he did say that in response, Mr. Turpin still would have asked the exact same question. And then, but if the officer would have said that in response, and then the question, if it's the answer to the question that determines whether the question is a revocation, then it's hard to see how the question can be a revocation,
well,
right?
I think that in legal terms that the cases sometimes refer to is that a question like that on behalf of Mr. Turpin is inconsistent with someone who consented to something.
See, the problem for you is that later on, when he did try and revoke the consent, he knew how to do it. He did it in very, very clear terms. It wasn't just a question. How did you happen to be here? That, as the chief is saying, that could be construed a lot of different ways. It certainly was not an obvious revocation of consent. I want to ask you one thing, just to make sure there's no confusion in my mind. You're not doubting that the drugs were in plain view. Is that right?
Apparently, the drugs were in plain view. I'm not arguing that.
Okay, I
Question
just
is-
wanted to make sure I had the record straight in my head, so.
Now, and also, I'm not consenting as to what type of drugs they were.
No, I wasn't.
Right, exactly.
I'm just asking whether.
Right.
Because there's another way to argue the case if you're contesting plain view, but my understanding was that you are not, so that other way doesn't matter.
No, I think the key thing is the sequence, when it occurred and so forth. And it's very clear from the evidence, from the body-worn camera footage, it's not a mystery that the issue regarding the plain view of the drugs was clearly after what I refer to as the revocation. The court and so forth.
What I would refer to the clear revocation after the drugs were uncovered. Then he clearly said, I want you out of here. Then he said it.
Oh, well, Your Honor,
Or something like that. He said,
he did. I mean, but that's not the only way that one
I
can.
understand,
Right,
we're
and-
going around in circles on that, but I get your point. I understand.
Right.
And it wasn't, the reason I asked about plain view, when I looked at the video, it wasn't clear to me whether if I just walked into that bedroom, as the police were allowed to do, if I just looked on that night table, that I would know that those packages, whatever they were
And
were drugs, but you didn't raise that as an issue. Because I think the police opened whatever the package was.
let me say this, Your Honor. There's a lot of speculation on the other side as to when this occurred. He didn't come in and immediately say, give any indication that he saw the drugs in the drugs. He didn't say anything about it. The only notification that came in was when he arrested Miss Jackson. Up to that point, there was nothing said and so forth, and they were just talking. So you can't infer that as soon as they walked in the bedroom, well, okay, they saw it. If he saw it, he didn't say anything, and that's not a big. You can't make that assumption without it.
He didn't go back to the bedroom, is that correct?
Yes, he went out back to the bedroom without consent of that occurring also. And I wanted to say, I'm out of time, but I reserved some time.
But I'm asking, when you say that, why are you here? You're saying he went back to the bedroom after that?
No, they were in the bedroom at that time. Everybody was in the bedroom at that
Okay.
time.
And then one officer left with Mr. Turpin after that.
Right.
Yeah, they forced Mr. Turpin to leave and so forth, to go to another room while he interrogated Ms. Jackson, or attempted to interrogate her.
But I was just trying to get at your question about, they never said anything about the drugs. Your statement suggests that everybody had gone to the living room or outside or something, and then somebody went back to find drugs, as opposed to they were already in the bedroom and they could see the drugs.
Yeah, they could see it, but in other words, no one, including the district court judge, could know when they saw it. The only way that one would know that they saw it is when they made the arrest. That was the first time that that issue came up. There's nothing in the record. And once again, this is a case for judgment on the pleadings. So you're very limited to what evidence you can use to make your argument. There was nothing that the district court knew about when they actually saw it for the first time. The first time that comes out on the record was when the arrest was made. Up to that point, they were just talking. Well, what are you doing? Well, why are you making all of that noise? He asked that, I don't know how many times. Well, what was going on? Well, there was nothing about the drugs. There was no arrest at that point.
But what do you contend the arrest was for?
Well, it was for the drugs and so forth, allegedly. But with respect to how one can make a statement, a definitive statement as to when that occurred, you can't do that. You can't make an assumption that as soon as he walked in the bedroom, well, he saw it. Maybe he did, maybe he didn't. If he did, he didn't say anything about it.
That wasn't an issue. You got to raise something like that. Yes, could it have been raised? Yes, could have. But when the second cop went into back to the living room, there was a back and forth, and he said, "What are you going to arrest me for?" He said, "Drugs, I guess." So they had seen something, and they surmised they were drugs. They were past
that was after the colloquy and so forth. That was after that discussion.
Yeah. So, but they had seen the drugs by then, and they told them, "We're going to arrest you for drugs."
Oh, well, there's no dispute about that. They did. There came a time after the sequence, after the colloquy, and what I refer to as a revocation. And no, it wasn't. He didn't say, "Get out of my house" at that time during the colloquy. But at the same time, his statements were totally inconsistent with someone who had given consent.
Let me make it real clear for me. If you concede, and I'm not saying you should concede, if I had you in a chokehold and you had to concede that your revocation argument is wrong, it's not borne by the record, so it's not in play, your client unfortunately would lose. Is that right?
Well, if there was no,
Wait, just for my head, I'm a slow thinker now, okay? If you had to concede or acknowledge that your revocation argument does not work, your client would lose, right?
yeah, if the revocation argument,
We don't buy it.
well,
I have to ask questions so that I understand how you're arguing. If we don't buy it, you lose, right?
yeah, if there was no revocation, if there was no colloquy, then that's a different
Don't buy into the
situation.
notion that he's slow thinking now. That's contradicted by everything any of us have seen for a good while.
Okay, thank you, Counselor.
Okay, and as I said, I did reserve some time.
We'll give you a little bit of time for rebuttal.
Thank you.
Mr. Phillips?
Good morning, and may it please the court. Graham Phillips on behalf of the appellees. I'll start with revocation because I think that is understandably where the focus was this morning. I think this revocation argument based on this question that Mr. Turpin asked fails for two independent reasons. So the first is just that this question did not evince a revocation of consent under the Fourth Amendment. And I think the appellants have not disputed our assertion that a revocation of consent under the Fourth Amendment needs to be unequivocal. They cite with approval the same authority that we do on the nature of what constitutes consent. So then the question is the question here, quote, how is it that you are able to be in my house, an unequivocal revocation of consent? And I think the answer is definitely not. In the first place, I think there have been some questions that rightly raise what exactly does that question even mean as a question? It's not clearly a question about the officer's legal authority. And the way that Officer Lorraine answered it is he didn't take it as a question about his legal authority. The way he appeared to take it was a question about sort of, why are you here? What triggered you coming to my house? And he answers that it was because they got this call about a noise complaint and potential fighting. And Mr. Turpin does not respond, that's not my question. That's not what I was asking. He says, I didn't call you, which is a fine answer, but it certainly does not support the notion that what he meant by his question was, what is your legal authority to be here? But even if you assume that the question was intended to mean or could be read as, what is your legal authority to be here? A mere question about the officer's legal authority is not a revocation of consent. To start, it is only a question. And it's a question that you can imagine someone in this position asking for a very rational reason other than revoking consent.
Consent to search?
Excuse me, Your Honor?
Consent to search?
Well, I don't...
The cases split it up sometimes. Consent to enter may be one thing as distinguished from consent to search.
That's true, Your Honor.
And your answer is, I just want to make sure I'm understanding the arguments here.
Yeah, I don't think...
There was no consent to search.
Right, we're not. Our position doesn't hinge on him having consented to a search because...
It can't, because there wasn't ever any. So your argument is?
That he consented to their entry into the room where drugs were in plain view. And so it's not a case where they...
And that wasn't pressed at trial, because I must say it was far from clear to me what was being picked up. If you pick up a bag and then you open it and start looking, I don't know that you can do that to make it in plain view. But that wasn't pressed, right?
Yes, I agree. And that's... I understand your position, but I do think the key thing is that has never been a disputed part of this case. So I just to get back to what I think this question could mean other than revoking consent, you can imagine that someone in this position wants to know, even if it is a question about legal authority, that they want to know, do you also have a warrant? Because you could want to know that because it could inform how you interact with the police. You could want to know the nature of their legal authority so that you can decide whether I could revoke my consent later if this interaction starts to go in a direction that I don't like. But to sort of put the point simply, merely asking if the officers are there on the basis of consent is not the same thing as revoking consent. And I'm not aware of any case in any jurisdiction that sort of equates those concepts. So I think that's the simplest way to resolve this revocation argument. And I think as counsel conceded here at the podium, that sort of is the end of the case. I do dispute as a secondary matter, dispute the sort of the timing argument. I think it certainly is true that this question gets asked before the officers have actually sort of picked up the drugs or mentioned the drugs. But when they mention or pick up the drugs is not the relevant inquiry. The relevant inquiry would be when were the drugs in plain view, thereby creating probable cause. And I understand that you could have questions about that. I do think the baggie that
Not on the video.
What?
It's not on the video.
I think it is, Your Honor. I think before this question gets asked, you can see the TV stand right there, and the objects that we're talking about were just sitting on the TV
But
stand.
we don't know what those objects are. You can't go very far with this. I mean, you're lucky it was never contested. It is not clear to me what they actually saw. Because my first surmise was there was a bag with something in it because they pulled something apart. And I would have argued as counsel, it's not plain view. He didn't see anything. It would cause you to know that was drug. Maybe you, because you watching them and wondering whether they were under the influence, you just assumed maybe. So you started pulling things apart. You don't have much with that argument. Your only argument, as I understand this record, your only argument is it was never contested.
Well, we certainly went on that basis alone, and I'll just leave it there then, because I do think you don't need to get to that because of that concession or that the sort of forfeiture. You don't need to even get there unless you think the question was a revocation of consent. And for the reasons I've just discussed, I think it plainly is not.
And you'd still have to deal with, even if it got past that, you'd still have to deal with the standards for a judgment on the pleadings too.
Right.
Because it would have to be in plain view, so plainly that would result in conclusion of plain view as at that threshold stage of the case, which is another complication.
I think that I think we would argue it, but I agree that would be a complication in a case where the plainness of the view was actually disputed, but it was not below. It has not been here. Unless the court has any further questions, we'll ask that you affirm.
Thank you, Mr. Phillips. Mr. Presley, we'll give you 2 minutes for rebuttal.
Well, just for the record, Your Honor, I had requested 5 minutes.
Right. Sometimes the arguments go in a particular direction, but there's only so much time left.
Your Honor, I wanted to say a word about another important issue in this case, and that is the come in statement and so forth. The other side is making a major issue about that statement. And just as Your Honor mentioned something about how in the colloquy, the statement could mean various things. Well, that certainly applies to come in. It's not as definitive as the other side would like. And once again, if you have a reasonable officer dealing with that particular issue, that particular officer would have to know that come in under normal circumstances is a situation where, let's say that someone comes up to your door, it's raining outside, they're the solicitor. You might say, well, come in. Does that mean that that person that you've asked to come in has the run of your house, can go to your bedrooms and so forth. That's absurd. And no reasonable officer would be able to draw that conclusion. And it's, if in fact there was a serious concern about coming in and giving this statement, these two words, all of this power and so forth, is, with all due respect, ridiculous and not something that should be considered in that way. People say come in and so forth, and the average person and so forth commonsensically understands what that means. If you ask anybody to come inside, typically what it means is you step inside the door, on the other side of the door, come in and say what you have to say. The officer ostensibly wanted to just talk, so to speak. Well, he also wanted to search, and that's obvious from the video.
So from this argument, just so I'm understanding, this is acknowledging that come in means you can come inside the house. What you're saying is it doesn't necessarily talk about the scope of what you can do when you come in, but you're saying that it at least means you can come in the house.
That's what it means under normal circumstances. Now, as to whether, obviously that didn't occur. He did. If in fact that was really meant in that fashion, Mr. Turpin would not have stepped outside. He came to the door and stepped outside. Now, also, it's very important to understand that Officer Lorraine also had a different understanding about what come in meant. He had the opportunity, if he really believed that it meant come in, he could have come in. The door was open, actually. He cracked the door open. This is all on the video. He cracked the door and reposed himself. If he thought that he really could come in, he would have come in. He didn't come in, okay, and so forth. So he didn't really believe that it meant come in. Mr. Turpin didn't say when he came outside to talk and so forth, which they originally agreed to when he was at the window when they first came up and so forth, Mr. Turpin stayed outside. Okay. He didn't say, well, guys, okay, come in. He didn't really mean that. So just as you indicated about how what I think is a revocation based on what he said and so forth. But at any rate, I see my time is out, but I think you understood my point. Okay. Thank you, Your Honor.
Thank you, counsel, and thank you to both counsel. We'll take this case under submission.
Case number 23-7173. David O'Connell versus United States Conference of Catholic Bishops appellant. Mr. Blomberg for the appellant, Mr. Double for the appellee.
Morning, counsel. Mr. Blomberg, please proceed when you're ready.
May it please the court, Daniel Blomberg for appellant. I'd like to reserve 3 minutes for rebuttal. The plaintiff wants to take back an offering he made to the Pope because he doesn't approve of how the Pope used it. He doesn't allege he asked the Pope for his money back or invoke the canonical remedies available from his church. Instead, he sued in civil court. And that fails for 2 reasons. First, it violates the religion clauses. This case requires second-guessing the religious meaning of inviting Catholics to support their Pope's charitable works, invited by a priest from the pulpit during Mass and an ancient worldwide offering. Religious entanglement here is inescapable as a matter of law, and that's why these claims can and should be dismissed by this court now.
But is there really a request to offer money for this purpose with a statement of why you're doing so? Because that's where you seem to be going with the church autonomy document to suggest kind of sincerity in the beliefs or what the religious doctrine is, or what are some of the internal workings of the court, as opposed to what the claim here seems to be is you're submitting it for this purpose, and is the purpose for which you're submitting it for the purpose for which it has been used?
Right, Your Honor. And so the issue is, and the difficulty is that the offering, the invitation to give to the church is on its face religious in nature. It says you have the opportunity to submit to assist in the charitable works of Pope Francis. Now, to be clear, we don't know exactly what the plaintiff heard because he doesn't allege that. If you look at paragraph 34 in the complaint, it's the only place he says anything about what he heard, and he doesn't tell us exactly what he heard. Instead, he said USCCB directed the parish priest to say something, which raises another church autonomy problem. But the one we're focusing on here, and to your question, Your Honor, is if you go to paragraphs 21 and 22 of the complaint, and I think that's all you need to look at in this complaint to see where this case should go. Paragraph 34, 21, and 22. He says, this is exactly what USCCB said that I want to hold them liable for. And that is that you have the opportunity to assist in the charitable works of Pope Francis, to be a witness to charity and help him help those who are marginalized.
Counsel, your biggest problem is, from my view, this is a collateral attempt at collateral order. You're in a losing area almost by definition. There's no case, and I've looked at all of them, that supports your position. None. Supreme Court had one on this issue, and with Justice Alito pointing it out, they refused to grant cert. All the other circuits have gone the other way. The cases you cite were not collateral order cases, or they involve situation you're trying to have kind of this grand First Amendment notion. If it's a First Amendment issue, it can be collaterally attacked. That's not true. And the cases you cite are about situations in which the plaintiff had been enjoined or blocked from doing something positively. That's an entirely different situation. But what I want you to understand, at least from this judge, is I've been involved in this area for years and years and years. It is almost impossible to get a collateral order attack. And there is no First Amendment exception broadly, and the religion clause exception has never evolved in the way in which you wish it would. Never.
Thank you, Your Honor. So a couple points on that. So I think the seminal case is from Judge Rogers of this court before she was on this court, when she was on the chief judge for the DC courts. And she said there that the religion clauses do provide an immunity against in a claim that on its face and as a matter of law requires inquiry into religious matters. And that's been the position of the DC courts since 1990. It's been reaffirmed several times.
District court here, and why is district court wrong, said on its face it doesn't.
Well, that's because, Your Honor, I mean, the oral order we have here doesn't get it.
Churches are not immune from civil suit.
Correct, Your Honor.
Okay, so we know as a starting point, the churches can be brought, even though they're churches and they're involved with religion, that doesn't mean they can escape all civil suits. That's simply wrong.
Absolutely.
So
Your
now you're in collateral order land, and that's the worst place to be, because our case law is so clear, including the Supreme Court, we don't allow it. It's got to be one of, I think, 8 or 9 categories. That's it. And you're not in it. And every circuit that has seen this has rejected it.
Well, and beyond Judge Rogers' order in the White case, there was also the Fifth Circuit's decision in Whole Women's Health and the Seventh Circuit's decision in McCarthy, both of which were dealing with religion clauses defenses. And the religion clauses defenses were rejected by the district court, and the courts of appeals exercised collateral order jurisdiction to address it. And the key here, and I think you see this in the other cases too, in Balia, in Judge Chin's decision in Balia, and in Judge St. Eve's decision in Garrick, the key is that the claim has to, on its face, as a matter of law, require inquiry into the religious matters devoted entirely to the church.
Can I ask how this would play out? So, I mean, I share Judge Edwards' concerns about this because, I mean, you at least have to acknowledge that the Supreme Court has been pretty restrictive in when collateral orders can come up, and its cases point to a very circumscribed inquiry as to what are the category of situations in which collateral order is available for all kinds of understandable reasons about the practical implications for the litigation. is the way this would work, given the way the church autonomy doctrine works, as follows, that you bring a collateral order appeal now. Let's suppose that at this stage, the court disagrees that, let's suppose, just for argument purposes, that you get collateral order review. Under your argument, you should. And then the court disagrees that there's an entitlement to church autonomy at this point. Then it goes back down, and as Judge Cobb herself contemplated, the proceedings go forward, and then the claims start to take shape. And then there's another assertion of church autonomy. This is, wait, okay, now that we see what this claim is, where it's really going, we've narrowed the allegations, we sort of rooted out the stuff that's extraneous, and now we see it actually goes to in the heartland of something that's ecclesiastical and can't possibly be second guessed. And then that assertion is rejected, and then you get another collateral order appeal.
Yes, Your Honor, that would be correct.
And then that could go on as the case winnows.
It would be similar to the qualified immunity context, Your Honor.
Well, sort of. I mean, you're right that it's similar in that in qualified immunity, you can have more than one collateral order appeal.
Yes, Your Honor.
But I don't know that qualified immunity has the degree of fluidity that would seem inherently to attend church autonomy, given that all the cases, including our cases, where we've contemplated the same sort of dynamic that Judge Cobb contemplated, that there may be ways in which the litigation develops that brings into sharp relief church autonomy concern that might not otherwise be apparent on the face of things. And it just seems like it's not a fertile ground for collateral order review when there's that degree of fluidity and possibility of repeated. In fact, what seems more appropriate in that context is 1292B, because that's classically one where, which I don't think you've asked for yet. I mean, you still could, I think, and we'll see what happens with that if this ends up going back down. I don't mean to predict what's going to happen, but 1292B kind of takes into consideration, based on the statutory criteria themselves, exactly these sorts of questions. Is this something that ought to go up right now? Does it make sense for it to go up right now? Is it reasonably in dispute? And does it make sense, given the practicalities of litigation, that it's something that the Court of Appeals ought to look at right now?
Yeah, and let me push back slightly on the idea that it's so, the right is broad in the sense that it protects the church, but only in certain areas, and it's deep in those areas, right? And so again, the DC courts since 1990 have recognized the right of collateral order appeal under the Cohen factors. You know, Judge Rogers walked through every element of the Cohen factors, said these apply right here. They've only been a handful of cases in those 35 years since that time that have gone up on collateral order, because you still have to show that the claim on its face and as a matter of law creates the church entanglement problems that we're talking about here. And I think
maybe the defense just wins a lot, or it just doesn't come up a lot, so you don't have that many collateral order opportunities. But you may have done the analysis and shown that they're actually.
Well, I think actually that is part of it, Your Honor, and that church autonomy cases are fairly rare. I mean, this court has seen very, very few over the last 40 years. Really, we're talking about less than a handful. And just because a church is involved in a suit doesn't mean, a house of worship is involved in a suit doesn't mean there's a church autonomy issue. And so, and even then you have to ask the question of, is this claim on its face deficient? And so imagine the claim is the Pope Catholic, right? Federal courts don't adjudicate that. Civil courts don't adjudicate that. This case asks, is the Pope's charity Catholic? And we think the answer is exactly the same.
But does it ask that? Or does it ask, you've asked us to donate money. You said the money was going to this cause, and did the money go to that cause? Why can't that be segregated out of any notion of what the charity is, and what the charity will do, what the religious beliefs behind the charity are, et cetera?
Yeah, and I think actually this goes to, I think, page 49 of my friends on the other side's brief really distills the issues in front of this court that helps on exactly that issue. So first they say, we're not contesting that the Pope used this money in a way that's authorized. It's a part of his authority. He is using the money in a way he believes is correct. He can invest it in overhead. He can invest it in an interim investment so the money grows and he can use it in other charitable ways. We're not contesting that. So that's off the table, right? And then he says, and we arguably agree that if the invitation had been, give this money to glorify God, that's probably not something federal courts could entertain. But you're saying, because the invitation here is support the charitable works of Pope Francis and be a witness to charity, that means this case can proceed. Those terms on their face are religiously entangling. For any court to adjudicate the claims in this case, they're going to have to ask a reasonable parishioner what a reasonable parishioner would have thought when they heard the priest from the pulpit during Mass saying, give to this ancient offering that's called Peter's pence because it's for the Pope.
The counsel, all you're arguing is what should happen at the end of the case. I can't get over the law regarding collateral. You want to try and move away from that. The law is too clear. This is a matter of all the ones I can think of off the top of my head, is so undoubtedly effectively reviewable after trial. It's almost amusing. This is straightforwardly reviewable. All these arguments making now, if the district court somehow went astray and reached where the district court should have gone, it will be caught on review. There's no case, none. You mentioned one or two, for example, where there was some pending action against the party, an injunction or whatever, and the court stepped in there. Barring those one or two cases, there is no case that allows a collateral order appeal in this area, and certainly not your broad, it's a First Amendment case, so it should go up. There's no such law.
Well, Your Honor, let me clarify.
If it's effectively reviewable, you lose, right? That's a three-part test. You must be able to answer that. This is effectively reviewable.
It is not effectively reviewable. You're right. We do have to show that. And so, and just to clarify, we're not saying that every First Amendment defense goes up on interlocutory appeal. We're saying that if the claims on their face, the judicial action that's being appealed on its face requires interference, a violation of the right in question, then it can be reviewed. Now,
Why? Think about the theory of collateral order. Why? Anyone would say, you realize how many of the claimants in these collateral order cases all come in and say, this is a really important issue to us, Your Honor. This will ruin us if we have to try this case, the forum non-convenes cases, this case should be decided in another country, except they all come in with exactly the same argument you're making. That is, this is unfair, it's a waste of time, our contract says this, blah, blah, blah. And we have said routinely for years and years and years, you wait until the end of the case, and then we'll see if there really is a problem, and we won't have to guess.
and Your Honor, if our argument was this is a waste of time, it's inefficient, then I would agree, but that's not our argument. Our argument is that asking the question of what the Pope's charitable works are is facially
I
entangling.
knew you were going to say that's not the test. The test is not whether we look at the merits of the claim that from the person who wants collateral review and see whether it's facially clear who should win or lose, because the Court of Appeals would be flooded if that was the test. That is not the test.
The test,
It
Your Honor.
may be facially clear, and you still have to go through the process so that we have a clean record and the courts can operate the way they're supposed to operate.
So I think the test, Your Honor, it cannot be just an efficiency argument. It has to be a right of sufficient importance, which is
No. It's not just the right of sufficient importance. There's
Correct.
Lots of cases.
not just that, Your Honor. I agree, not just that.
Okay.
But it also has to be that the right will be lost if the case is permitted to proceed.
Right, and no right will be lost here.
Yes, Your Honor.
No, not until someone orders something. And if the district court doesn't order something that's not reviewable, then you can't make that claim, because the district court can do nothing more than issue an order which would be subject to review if you think the district court went too far.
Your Honor, in this court's decision in Woodrick v. Marsh, even limited discovery transgresses the right at issue if we're right that we have an immunity here.
Was an injunction there?
No, Your Honor. It was Westfall immunity that was at issue. So the question is, does the church have a right against interference in the internal workings of its decision-making process? And if there's a colorable argument that the church does have that right and that the claims here violate that right, then this court has jurisdiction to consider that very, very narrow issue. If there are disputes
If you conceive of it as a right that means that the church shouldn't even have to undergo litigation to determine the applicability of the defense. And there's always going to be this dynamic, and it came up with attorney-client. The way attorney-client works is that actually there shouldn't be a disclosure to begin with, and the Supreme Court rejected that because it kind of conceptualized the right in a little bit of a different way. And so it takes on a dimension of circularity with it.
So, Your Honor, I think the key here is you're right that there has to be some degree of litigation to determine the applicability of defense in some cases. A good example of that in the church autonomy context is the ministerial exception cases, right? Where do we know if this person is a minister? Sometimes it's clear, like in this court's Minker decision, on the face of the pleadings, it was clear that person is a minister, case closed. as it regards their age discrimination claim. I'd like to get to their contract claim in just a second, because I think that's really helpful with your questions, Judge Childs. But when it's clear on the face, allowing any further proceedings is violative of the right. Remember, the right here we're talking about is a right to autonomy in the church's internal affairs. So the court has the ability to question, are we addressing that autonomy? Have we got into that space of faith, doctrine, and internal church governance the Supreme Court talked about in Our Lady? If we have, then case should be over. Again, is the Pope Catholic? We don't get to resolve that. Is the Pope's charity Catholic? That's what this case is about. It also isn't something that courts should be able to resolve. And I think the Minker case is really, really helpful on this point.
You could, in that situation, there is 1292B, and there could be mandamus. I mean, we've had cases where even after Mohawk, in the attorney-client context, attorney-client privilege context, if there was a clear case in which attorney-client privilege should have been granted, even if it's an early stage in the proceeding, litigants have gotten mandamus relief in our court.
Yeah, two points on that, Your Honor. So one, Mohawk expressly carves out structural constitutional defenses. And the Billard case by Judge Harris says church autonomy is structural constitutional defense that protects not only the right of the church, but also the duty of the court, right? But two, on 1292B, plaintiffs or defendants, churches do try that defense. They tried it in Garrick, the court said no. They tried it in Bailey, the court said no. We looked at it here, and the judge's oral order didn't indicate any sort of, thinking this was a close issue. And so it didn't seem like we had a reasonable path forward.
At this stage, maybe. I mean, I think that's one of the salutary aspects of 1292B in this context, is that it could be that the case gets to a stage where a district court could conclude, okay, we're really joint issue at this point, and I'm going to say that there's no church autonomy defense that precludes going forward, but I can see that there's a reasonable question about this, and so I'll grant 1292B.
Right, and maybe, if we had been at a different time, the Huntsman case, the en banc review had already been granted at the Huntsman oral argument, which pretty clearly indicated that we're talking about very severe religious autonomy issues. Maybe Judge Cobb's decision would have been a little different, but we had a short oral order that indicated, it decided two cases. So, and that's part of the right here is the ability to go up, because, if the court says no in 1292B, we can't, right? And so we need to be able to, if the court has gone outside its lane, which is what Judge Harris talked about in Billard, have the right to get a court to review that. Now, this court doesn't have to.
Outside its lane because it hasn't rendered a ruling on the merits of the case. That's exactly why the collateral order doctrine is what it is. Join the crowd of litigants who all believes they can't believe they're having to wait to get the final judgment. But that's the way we work. You are not an exception to the rule, and you're not presenting a compelling case to show that. Merely because you think this is so onerous, this is so unfair, does not overcome the law, which says you wait unless it's effectively unreviewable. And it's not effectively unreviewable by you merely saying, but this is really important to us. That's not the test.
And I agree, it's not the test, Your Honor. And I see my time is up, so just one point, then I'll sit down. But we're not arguing it's because it's onerous or unfair. We're arguing because it is inherently entangling on its face to have a reasonable parishioner answer the question of, do you want to assist in the charitable works of Pope Francis? And that's precisely the issue here. I'll reserve the balance of my time, Your Honor. Thank you.
Thank you, counsel. We'll give you some time for rebuttal. Mr. Dobley.
Good morning, Your Honors. May it please the court. Gabriel Doble on behalf of the appellee, David O'Connell. USCCB asks this court to expand the collateral order doctrine in a way that no circuit has done, that 4 circuits have expressly declined to do, and that the Supreme Court has repeatedly cautioned against. USCCB seeks a new categorical right to immediate appeal whenever any defendant in any case raises a church autonomy defense on a motion to dismiss. As this court recognized in the Doe versus ExxonMobil case, such a holding would be directly contradictory to the Supreme Court's repeated admonitions that the doctrine remain narrow. And to your point, Chief Judge Srinivasan, about the repeated collateral appeals, if USCCB is right, it's not just motions to dismiss that would be immediately appealable. It would be a motion to dismiss, a motion for summary judgment, and every single discovery order in between. All a religious defendant would have to do in response to document production requests, in response to interrogatories, in response to depositions, is say this discovery intrudes on our religious autonomy. And they'd have an immediate right to appeal the district court's order granting that discovery.
But that is based upon the assessment of what the particular discovery requests, like the judge could just look at that before allowing the discovery.
That's correct, Your Honor. But if USCCB is right, all it would have to do is raise a colorable argument that that discovery intrudes on his church autonomy, and then get an immediate right of appeal with full merits briefing.
Well, the point I'm getting at is that all the arguments seem to have gone to, you're going to make us go through all of this expensive discovery. They're going to already have all these answers. They're going to invade into our provinces, of our religious institution. And then you're asking the court to rule. What I'm asking you is that when you, as a plaintiff, craft these questions, craft these requests for production or requests for admission, would the district court be able to just look at that questioning on its face and decide what to allow in or exclude, or determine that, okay, yeah, you really are getting into this church autonomy doctrine, and so therefore that's enough. Just freeze the litigation basically at that point, then allow it to go up right then. Because the other side is arguing that we're going to go through all this expense just to get right back here.
Yes, that's exactly right, Your Honor. And that's the heartland of what the district court is in charge of, is handling discovery. And the district court, if a discovery request goes too far, can say this intrudes on church autonomy, I'm going to limit this discovery request. And the district court, in this case, Judge Cobb, said she would do that.
Okay, but what do you anticipate that you would ask for?
Well,
like to get to this claim, because earlier I was saying, it sounds like your argument is there was a message from the pulpit that says donate to this charity. Then the person donates, and then you could just look at the records to say, did it just go to the charities that you agree that they have the opportunity or authority to send to?
well, it's not just a message of please donate. And my friend on the other side omitted some important language from the USCCB promotional materials. And that language is that the funds, and I'm quoting from the bulletin announcement.
Yeah, and I did mean to add that you have a written document as well that you're relying on.
Correct. There's a written document, and there's also a document that USCCB sent to parishes saying, please read this text from the pulpit. And what both of those documents say is not just, please donate this money for the charitable works of Pope Francis, is please donate this money and the funds will help victims of war, oppression, disease, and natural disaster. So if this court were to reach the merits of the church autonomy defense, which I don't think it should because it doesn't have jurisdiction, but if it were, the district court got this right, that this was a classic claim of fraud that happens to have a church as a defendant. All those words, victims of war, oppression, disease, those are secular words. It doesn't take any interpretation of canon law to understand what they mean. So for that reason too, this appeal fails.
I think even Judge Cobb, let's just, because we're on this axis right now, go past the collateral order question just for a second. I think Judge Cobb recognized that depending on the way the claims in this case take shape, they could well bring into play church decisions that may be problematic for courts to investigate.
That's correct, Your Honor. She expressly recognized that it's always possible that a case against a church could bring into play religious issues. And she expressly said, I can't and I won't rule on those issues.
And there's nothing about the nature of your claims that immunize it from that kind of scrutiny, because even though you have claims that at some abstract level sound in broad conceptions that you can understand generically, they don't necessarily intersect with church decisions. The terrain is such that those claims, the way they're litigated and the way the merits of them may shake out, it could encroach on that territory.
That's correct. We're not saying that churches are subject to every claim conceivable. We're saying that churches are subject to secular claims that can be resolved using neutral principles of law. And that's been something that the cases all over the country have recognized. And even in the Huntsman case in the Ninth Circuit, Paul Clement, counsel for the church in that case, acknowledged that oral argument. If a church makes a specific misrepresentation about how solicited funds will be used, that's a fraud claim, and a plaintiff can bring that claim. And that's exactly the type of claim that we have here. at least at the pleading stage, like Judge Cobb determined. And now this isn't I'll go back to the jurisdictional point for a second. The lack of jurisdiction here doesn't mean that defendants who actually need an immediate appeal won't get one. As Chief Judge Srinivasan, as you pointed out, there are mechanisms established for litigants who actually need an immediate appeal to have one. Those include Section 1292B and the writ of mandamus. And the Supreme Court and this court and many other circuits have recognized that these avenues of immediate appeal are preferable to church autonomy, or excuse me, to the collateral order doctrine, because unlike the collateral order doctrine, they limit the right of immediate appeal to litigants who actually need it, rather than creating an entire category of immediate appeal for any defendant who could conceivably raise a colorable church autonomy defense. I'd like to highlight two cases that I think are specific, that are especially on point to my friend on the other side's argument of a right not to be tried here. And the first is the Supreme Court's decision in the Ohio Civil Rights Commission versus Dayton Christian School case, where even in the context of an invasive government intrusion investigation into an employment discrimination claim against the religious school, the Supreme Court said church autonomy rights can adequately be vindicated in a post-investigation judicial review. The religious school in that case sought to enjoin a state administrative proceeding against it investigating a sex discrimination claim. The Supreme Court held under the Younger Abstention Doctrine that proceeding, that investigation could proceed. And an important basis for that holding was that the church's church autonomy rights could adequately be vindicated in a post-investigation judicial review. That forecloses the argument on the other side that church autonomy rights are effectively unreviewable if not vindicated before that investigation occurs. Second, I'd like to highlight this court's decision in the ExxonMobil case, in which this court held that the political question doctrine is not collaterally appealable. The other side's argument is that this sort of structural limitation on the judiciary's power to decide religious issues gives them a right not to be tried. And this court rejected that precise argument in the separation of powers context in ExxonMobil, and held that the defendant in that case made the same type of argument that mere adjudication of the claims would constitute judicial intrusion into the executive branch's foreign policy interests in Indonesia. And in that case, actually, the State Department filed a letter with the district court saying litigating this case could interfere with our foreign policy interests. Even in that context, the court said this type of structural limitation does not confer a right not to be tried. So for the same reasons here, dealing with church autonomy, that sort of structural limitation on the judiciary's power does not confer a right not to be tried. I'd be happy to answer any other questions the court has. Otherwise, I'll submit.
Thank you, Mr. Doble.
Thank you.
Mr. Blomberg, we'll give you the 3 minutes that you asked for rebuttal.
Thank you very much, Your Honor. Just a couple quick points. This court has never seen a case like this. No court has ever seen a case like this. This case tries to make the U.S. Conference of Catholic Bishops liable for what a parish priest said about how the Pope was spending his money in a worldwide offering. I have not seen a single case in the history of our country that comes anything close to what the plaintiff is asking this court to allow here. And he says that the court can manage discovery below. Our point about discovery is not that the court can't manage discovery. Obviously, courts can. Though I would hasten to point out that in Catholic University, this court emphasized that oftentimes it's very hard to do in the religious context. And in fact, a well-respected judge of this court threw up his hands afterward and said, actually, we couldn't. And we violated the Establishment Clause by our process of trial here. And the whole women's health case out of the Fifth Circuit said exactly the same thing.
But what is so different about, for example, courts managing discovery with the attorney-client privilege? In many instances, the court takes the matters under review in camera proceeding and dissect all the time, what's available to the parties or not.
Because that very process, Your Honor, is what violates the church autonomy doctrine. To require the church, to require the bishops to turn over their communications with the Holy See, which is what plaintiff has requested here, is a violation of the church autonomy doctrine.
But you have your colleague on the other side suggesting that the court could freeze the litigation with respect to just looking at the questions propounded, requests for admissions, requests for documents on the nature of what's being asked before you even turn over anything.
Well, 2 points to that, Your Honor. One, my friends on the other side say that they need and cannot succeed in their case without getting a copy of every expense the Pope made to this offering that is collected from Catholics worldwide, has been for over 1,000 years.
But in your written submissions, you state it's going to war, humanitarian, this, that, and the other. So if there were a listing of expenses turned over, it should show to those types of groups that are there, not to challenge whether you believe in the groups or not, but just that these are the types of groups under those subject matters.
Well, and that's exactly the problem, Your Honor, because this is not a case where the plaintiff is challenging that the Pope has used the money in a church in a way that's unauthorized by the church. He bought himself something nice. That's not permissible, basically theft. He's not saying that. He's saying, I can't challenge that, right? And so he admits that's okay for the church, for the Pope to have exercised his judgment to invest these funds and to run the Holy See, which is where many pilgrims come. So it's every year. It's a very important charitable purpose. And so he wants, and he requires on its face, his claims require a reasonable parishioner, this court, the civil courts, to determine what a reasonable parishioner, when they hear you can contribute to the charitable works of Pope Francis, including to victims of war, that must mean you can't invest it. You can't put it toward the Holy See. That's his argument. His argument, it must immediately and exclusively go only to victims of war. And that's what a reasonable parishioner would interpret this. That's not something courts can determine. That's
It's only an argument, counsel. That's not a judgment of a court. But you're assuming that because a party argues something, that's the way the district court will deal with it. The district court has assured us otherwise.
The district court has already ruled that the defendant's argument here has failed in terms
Also,
of.
keep forgetting that the church is not immune from civil liability with respect to secular matters.
Exactly, Your Honor. With respect to secular matters, this is a religious matter.
Why do you have to say the Pope? The discovery might be any directives you receive, any directives that you have, not about the Pope, but directives with respect to these contributions.
So the plaintiff's discovery request, which they say they need and cannot proceed without, that's a representation they've made to the district court, and they haven't withdrawn before this court, including they want all documents submitted to or received from the Holy See, Vatican City, Apostolic Nunciature, and any of their subdivisions, agencies, or agents related to the Peter's Pence collection. Your Honor, that's a worldwide request for documents going to the Holy See. What?
Has it been ruled on yet?
Your Honor, the point is.
Has it been ruled on?
No, Your Honor.
Okay, then we don't have the faintest idea what the district court might do. Again, that's where the collateral order doctrine comes in. We'll wait and see. It's effectively reviewable.
And my point, Your Honor.
Or, as my colleagues pointed, there are other ways to come up in the event of a really serious problem and not use collateral order.
2 points on that, Your Honor. One, this is a really serious problem. This is a very serious problem. My friends on the other side haven't identified a single case that's like this one. I'm not aware of a single case like this one. And then 2, Your Honor, the point isn't that the district court, Judge Cobb, couldn't restrict discovery. It's that the plaintiff has represented that he needs this discovery, that he cannot proceed without it. In fact, he's successfully gotten it in other cases like this, like the Gospel in Asia case that he emphasized below. And so if this case proceeds, that's where it's going, because he can't proceed otherwise.
That doesn't make
precisely the point.
That's such a silly argument, respectfully, counsel. You say to a district court judge, I can't proceed unless I get this in discovery. The district court judge can say, okay, I'll dismiss. The district court can restrict discovery as she or he feels it's appropriate. Your argument makes no sense.
Well, and that's part of my concern, Your Honor, is this was already represented to the district court in the motion to dismiss papers.
The district court hasn't ruled on this.
The district court, knowing that the plaintiff said, I have to have this to win, still said this case can go forward.
Different.
It may have been that the district court, in saying that it can go forward, had in mind a way of dealing with the discovery request.
Right.
We just can't know right now. Right? I mean, it doesn't mean that what the district court had in mind was, I know that the plaintiffs have represented this and I'm prepared to grant it. We just don't know. And if something happens as it goes forward, there are these other mechanisms potentially to get interlocutory review. If this truly is a path-breaking historical case that's going to raise some fundamental concerns, the likes of which the case law hasn't yet seen, those are circumstances in which there are mechanisms in place now to get interlocutory review, at least at that level of abstraction.
But only, based on the argument from our plaintiff, only with the district court's discretion or under the heightened mandamus standard, not under the standard that should be appropriate, that we argue here, that Professor McConnell argues here, that Professor Laycock argues here, and many other courts have recognized, including 10 appellate court judges, on this precise issue, that there should be a right for appeal in this instance. Thank you very much, Your
And I
Honors.
think a lot of those briefs to suggest that we, as this court, need to recognize the church autonomy doctrine. And I don't think that there's been any suggestion here that we don't recognize the doctrine.
Correct. The point isn't that recognizing it. This court has recognized it for a long time. The Minker case recognizes the autonomy of the church expressly. So does the Catholic University case. So does the Duquesne case, Great College, Carroll College, Great Falls. All of those cases have recognized church autonomy. The question here is the scope. Does the scope of church autonomy protect you from a court from inquiring into whether the Pope's charity is Catholic? We think the answer is yes. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you. Honorable Court now stands adjourned until Monday, January 13th at 9:30 a.m.